unfortunately, we have to go to the root. We have to go to the cause. Dealing with the condition itself is not enough.
Dear Mr. Massa, I'm just trying to mind my own business. What's the matter? It's just another day, another black king captured. I'm about to lose my brain, stuck inside this ghetto rapture. I got a lot of smoke. If you want it, you can have it. They want a hat trick, but this is black girl magic. Ain't talking about the kind that'll make you disappear, but I'm talking about the power of the melanin within. Ain't looking for trouble, but I'ma say this one time. I put two dukes up if you try to touch mine. We still want justice for Samir and Trayvon. You say you don't see color, but racism ain't blind. They targeting little kids whose skin look just like mine. So I'm paranoid, it's a war zone outside. And I'm a black queen, so if you ask me to step out of my car, you gon' have to snatch me. Cause I ain't going no damn well. Had to spend my whole life living unfair. Ancestors got my back and they right here. You can never understand, it's a nightmare. Living in my black shoes by the black rules. You can keep your handshake, I don't dap coon. The white man will go nuts if he cash you. But you all on his side like a damn fool. Make it make sense.
We are oppressed.
Queen.
We are exploited. We are downtrodden.
Make it make
We are
sense.
denied not only civil rights, but even human rights.
Ahmadiyyah.
So the only way we're going to get some of this
Ahmadiyyah.
oppression and exploitation
Queen.
away from us or aside from us is come together
Queens.
against the common enemy. Who taught you to hate the texture of your
Ahmadiyyah.
hair? Who taught you to hate the color of your
Ahmadiyyah.
skin?
Parents, pay attention to the books, the school system, even to your little children. Lies mixed with wisdom. His skin too bright, so he was blind to the prison. My skin just right, so I collide with division. You trying to pray to God, but we tired of religion. No savior saving, we got to save our savings. We used to pay miss, how we gon' make the slave rich? But who's to blame, and tell me why you complaining? We need a team effort just to rule the nation. Like a bad relationship, missing communication. We missing moderation. They're trying to get a poison to my population. No reparations. I'm getting tired of Satan.
We are oppressed.
I'm
Queen.
getting tired of waiting.
We are downtrodden.
Queen.
We are denied not only civil rights, but even human rights.
Ahmadiyyah.
It's the one and only queen of receipts, the dropping gems in these YouTube streets. The lawyer Royce, nowhere to go. Tune in for the infamous morning show, giving the news that you need to know. So don't you dare miss a wake-up call. Then in the evening, I got all for y'all. Get your dose of daily vitamins. You know the queen makes it make sense. So true.
Is your mom and dad home? You need to put that down. You've been playing with water. Yesterday I had pictures and somebody sent me of you playing in that water. Where's your mom and dad? This is ridiculous. Stop spraying the water. I said stop. Give me the hose. Give me the hose. Stop spraying the water. Stop. Give me the hose now.
You can't tell me what
Give
to
me
do.
the hose. You're not supposed to be playing with the water.
Thanks for tuning back in once again to the original Queen Ahmadiyyah Shakur show. I'm your host, Queen Ahmadiyyah Shakur, and this is your morning wake-up call. So as you're coming in, please feel free to go ahead and hit that like button, okay? Like, share, and subscribe, okay? You can do that for absolutely free. It doesn't cost you a thing. Don't forget to follow me on Instagram at Dr._A_Shakur, TikTok at Dr. A Shakur, and Twitter at DGoddess27, all right? So let's get into it and see who's in here. Did y'all see that with the Airbnb? She just waltzed up in there like it was all gravy and then got mad and told the lady, don't you talk to me in that tone. Girl, she would have gotten a whole beat down had that been me. What are you doing here and who are you, ma'am? Okay. I'm sorry, but I would have absolutely chose violence. Because first of all, I'd have feared for my life. You're an invader. Who sent you? Okay, y'all know I'm just joking.
but maybe not. Okay. Hey, Red Wine Entertainment, Jeff ATL, Sandra Cookie, Mr. Elevation, Michelle, Witty T is in the house, Claudette. All right. Mr. Elevation said, what's wrong with these nefarious people? I know, right? Miss AP is in the house. Love her. Most hated bronze flat power God. Dervis is in here. AJ Matthews is in the house. Desmond M. Shanty is here. Buckhorse DC. Cookie is in here. Okay. All right, so let's get into it. Sandra, Stacy Quentin, Claudette. Okay, so listen, let's get into it. I want to thank you all for tuning in and let me shout out the replay gang. I forget to shout out my replay gang. I appreciate you guys for tuning in. Also, if you missed the live and you don't get your notifications, okay, Fat Boo is in the house, Jeff ATL. All right, Anita Harrell. So let's get into it. And listen, let's all give condolences to Desmond, my moderator. He's my chief moderator, and he lost his grandfather on yesterday. Okay, so let's give our condolences and prayers out to Desmond and his family for their loss. We love you, Desmond. Thanks for all that you do, beloved. Okay, prayers and condolences. All right, hey Bree, Bobby Wright said that little boy learned to spray people with water watching old civil rights marches. The old civil rights marches. Hey, Nessie X. John Drea is in the house. Hey, beloved. Okay, that's one of my new members. Shout out to you. Listen, let me tell y'all something. DJ Big Six, I see you. Let me tell you guys something. That man was dead wrong coming in that little boy's yard and telling him to turn off his hose. Now, why is he concerned about that boy spraying water? I have a whole lot of questions. He got just what he deserved, as far as I'm concerned. That little boy sprayed him down, okay? Hosed him right on down. That's what he gets. Okay, you don't come in someone else's yard and tell their child what to do and then further try to take possession of his house. Nah, I'm sorry. He did exactly what he should have done. Okay, you don't tell me what to do. That's what little boy told him. You can't tell me what to do. Okay, so anyway, let's get into it, honey, because Diddy is trying his darndest to get out of jail. Diddy is still trying it, honey. They have moved for a dismissal. Okay, his team is requesting a dismissal. Mark Agnifilo filed paperwork on yesterday. I was going to come back and talk to you guys about it, but y'all know how I be doing once I get out of here. And not to mention, I did 3 lives yesterday on this channel, the backup channel, and the spiritual channel. Okay, so anyway, listen, Mark Agnifilo filed paperwork complaining once again about Diddy not being privy to a laptop. Okay. And then his other attorney, Alexandra Shapiro, then she filed a whole 30-page document. Basically, they're requesting that they get a dismissal of the indictment. So let's get into it. Likes up, everyone, please like and share. I'm going to share my screen so you all can see the foolishness, because who does Diddy think he is? And who does he think we are? Diddy, you're not going anywhere. Okay, you're not going anywhere. Please pay attention. Okay, so let's get into it, because I find it all interesting that Diddy's done all this dirt and still he's trying to finagle his way up out of here. But you know, when you have liars who go around lying, okay, like Adria English and Lamisha Fuller, well, then you have to worry that some of these things could come back and inadvertently get him up out of there. Okay, and so please pay attention. This is why the liars have to be absolutely called out at all costs. Okay, because they're taking away attention, first of all, from the real victims. Now, I want you all to think about something. Let me just go on a tangent for a second. When you think about all these people out here telling these lies and stuff, okay, these 2 that I specifically just named, at the end of the day, they're taking away the focus from the victims. That's what they're doing. Okay. We're all reporting on them, of course, and then calling them out for their lies and BS. But prior to people realizing they were lying, well, I'm just going to be honest. I knew they were lying from the first place. You all know that because I told you. But nonetheless, when people are sitting there giving them, a platform to spew these lies or whatever, because they're fooling people and all they're doing is out here grifting, okay, asking for money with their cash apps and saying these sob stories and all the stuff, and it's all just made up, most of it, if not all. And this is all a distraction from the real victims, and it also serves to maybe allow Diddy's team to try to discredit some of the actual victims. Okay, so please pay attention to that. All right. And so with that all being said, and without further ado, let's go over this. Let's go over this. Okay. So here's what Mark Agnifilo wrote to the judge. And again, this was on yesterday. Dear Judge Subramanian, we write on behalf of Mr. Combs to request that the court direct the MDC to provide Mr. Combs with a laptop prepared for him by the government and allow him to use that laptop on his unit, consistent with the way other inmates on his unit are permitted to use their laptops. Now, 2 months after he was charged and detained on November 25th of 2024, the government provided the MDC with a laptop that Mr. Combs can use to review discovery and to take notes related to his case and otherwise assist in his defense. Now, in the 9 days since then, Mr. Combs has still not been provided with the laptop, despite numerous inquiries by defense counsel. Finally, this morning, the government informed defense counsel that after consultation with MDC counsel, Mr. Combs has 2 options related to his laptop. One, he will only be provided with the laptop in the unit's video teleconference room during select times when legal staff is available and when the room is not otherwise being used during other inmates' legal calls. Or 2, he will only be provided with the laptop in the legal visiting room between the hours of 8 to 3:30 p.m., but not both. Now, these restrictions are untenable and, from what we understand, not required of any other inmate on Mr. Combs' unit. They significantly limit the time available for Mr. Combs to use the laptop and force Mr. Combs to choose between using the laptop and meeting with his attorneys, who often meet with Mr. Combs over video teleconference. There is also no jurisdiction for these restrictions. To be clear, the discovery provided on Mr. Combs' laptop does not contain any evidence designated as attorney's possession only, and therefore does not contain anything that could potentially risk the safety or privacy of alleged victims or witnesses. Okay, then he refers them to docket 26. Now, while the terms of the protective order disallow Mr. Combs from disclosing the discovery to third parties, there is no reason to believe that Mr. Combs is going to show it to other inmates, such that a departure from normal MDC practice is warranted. Thus, there is no conceivable reason why such restrictions should be placed on Mr. Combs, nor could any reason outweigh his significant interest in reviewing discovery and assist in preparing his defense. Moreover, given the government's efforts to surreptitiously monitor and record his handwritten legal notes, Mr. Combs' need for a laptop to take legal notes free from government surveillance is heightened. Now, in addition, last night, defense counsel learned that the MDC has been providing the prosecution team, and not via the filter team, copies of MDC attorney visitation forms. Who Mr. Combs meets with in connection with his legal defense, including potential experts and investigators, is potentially privileged. Even if not privileged, this level of surveillance offends due process and hampers his ability to prepare his defense. The MDC has informed defense counsel that it produces such information whenever a defendant complains about inability to access his attorneys. Here, however, the defense has not taken issue with Mr. Combs' ability to meet with his attorneys in person at the MDC. Rather, Mr. Combs' inability to prepare for his defense stems from the restrictions the government has placed on his ability to receive and review discovery, and his inability to keep his privileged legal notes confidential. There is no conceivable reason why the government should know who and when Mr. Combs meets with in connection with his legal defense. Accordingly, we respectfully request that the court direct the MDC to 1, provide Mr. Combs with a laptop that has been prepared and provided by the government, and to allow him to use it in the unit, and 2, cease sending the government copies of attorney visitation forms. The government has indicated that it intends to file a response. Respectfully submitted. Okay, and this is signed Mark Agnophilo, honey. They are not playing games. Okay, y'all better stop trying him. Y'all heard what he said. Okay, y'all heard what he said. All right, so they don't want to give Diddy his laptop and all that. Love Her says they have way too many privileges in prison nowadays. I mean, that's what I'm talking about, laptops and all this. Okay, but in this case, I guess when you're trying to get your defense together, it would be okay. But it's the question. Mr. Elevation said Diddy has been coached to deal with jail. Well, you know that, beloved, absolutely. Because remember the video that I did about him meeting with that prison coach. Okay, y'all remember that? And now it was looking like they just accidentally bumped into each other in Miami. I told you guys that dude was a whole prison coach. He's been to prison himself, and he has a podcast where he tells people how to deal with things when they go to prison and how you got to have your paperwork right and all of that. And they better not find out that you a PDF file. Okay, which has been alleged to be one of Diddy's accusations against him. So it's all very interesting, honey. Okay. Vote blue no matter who said this ain't right. Let Diddy have the laptop now. Well, here's the thing. You have a point because if the other inmates are allowed to have laptops, okay, then he should be allowed to have a laptop too, if that's the rules and that's in compliance with everyone else. It seems like they may be just being a little prejudicial against Diddy. Okay, who knows? Not to say he doesn't deserve it, but no. But seriously, we all have a right to due process, no matter the charges. Okay, we all have a right to a speedy trial. To be privy to have. Private conversations with attorneys, to be able to have our information or evidence through discovery and all of that. And so it just sounds like they're being shady towards Diddy. So Overthought says we can't trust anything these lawyers say after that legal pad tomfoolery. I know, right? Letitia says, so remember that video, Queen the Coach. Yes, okay. I mean, Diddy needs to sit down somewhere. He was really doing the most. Okay. Overthought said nobody is violating his rights. Yeah, and they actually kind of are. You see, we, at the end of the day, listen, if they're letting other inmates use laptops, now mind you, that document I just read, this is my first time reading, as well as these 30 pages I'm about to whip out. Well, I did skim over those, the 30 pages. But here's the thing. At the end of the day, we don't want Diddy getting out on any type of technicality. Okay, so they have to do everything. They should be doing everything by the book. Okay, that's all I'm saying. So if he's supposed to get a laptop, then please, by all means, let him have it. Because I do believe that if what most of these victims are alleging is true, then Diddy's absolutely going to get what's coming to him. So, we don't need the feds to mess this up. That's all I'm saying. If they need not be depriving him of things that he's absolutely entitled to. Okay, not that we want to help him, but we darn sure don't want him getting out and wreaking any more havoc. Okay, as he's done allegedly for the past 30 years. So now let's get into this 30-page document, honey, because when I tell you Alexandra Shapiro was dragging the feds, okay, she was no holds barred. Please pay attention. Now, this also was filed on yesterday. So let's get into it. Likes up, everyone. Please like and share. And actually, before we get into this, let's go ahead and have a word from my sponsor at 12 Tribes.
Do not buy 12 Tribes on Earth hair growth oil and hair magic elixir unless you want super healthy, gorgeous hair that grows. They have a whole line of amazing hair growth products, including hair growth leave-in conditioner spray, hair growth shampoo, hair growth spray, and hair growth butter. I'm starting to sense a theme here. They include quality natural ingredients. They smell amazing, and you can see the results for yourself. So if you're looking for healthy hair growth for your natural or relaxed hair, try 12 Tribes on Earth today.
Okay, so guys, don't forget you can purchase 12 Tribes oil for your hair. And also she has oil for the men's beards and all of that. So you can purchase it at Etsy.com. Just look for Lisa Crafts. And you can also find it at Walmart.com. Okay, so let's get into this. So this is a memorandum of law in support of defendant Sean Combs' motion for hearing, suppression, and other relief. So they're demanding a hearing, honey, where they want evidence brought in. Please pay attention. And they have a whole table of contents. They are not playing games, honey. This is thorough. Okay? Okay, so Sean Combs faces enormous challenges in this case, not because of the evidence, but because he must defend himself and prepare for trial from jail. Pre-trial custody status is associated with the ultimate outcomes of cases, with released defendants consistently faring faring better than defendants in detention. So basically saying that people who get out on bail, it's easier for them to try to fight their cases. Now, ABA Standards for Criminal Justice Pretrial Release 29. Okay, they're referencing this. Okay, so, but if that weren't enough, the government exploited Mr. Combs' detention by engaging in unfair and unconstitutional tactics that have interfered with his ability to work with his attorneys and make it impossible for his attorneys to provide effective assistance of counsel. Now, I want you all to pay attention because y'all hear this. Now, see, right now, what they're doing is, they're setting the groundwork. See, this is why the feds need to be careful and do things by the book and not try to be prejudicial, if in fact they are, against Diddy. Because listen, they're laying the groundwork here when they start saying things like they're making it impossible for his attorneys to provide effective assistance of counsel. So if Diddy were to be convicted, he could appeal his conviction on the grounds of ineffective counsel. Okay, please pay attention. Now, the evidence shows the government is using Mr. Combs' detention to spy on him and to invade his confidential communications with his counsel. Now, since his arrest, the government has been working with BOP staff, including Investigator 1, to take advantage of his incarceration by meticulously monitoring all of his communications, including with his attorneys. And during a recent BOP sweep of MDC, Investigator 1 illegally, saying the feds is out here breaking laws, honey, please pay attention, said he illegally searched Mr. Combs' handwritten notes containing privileged communications and work product. Now, Investigator 1 photographed the notes and then shared them with the prosecutors. Prosecutors claim they did not request this search, yet they concede Investigator 1 has been investigating Mr. Combs at their direction all along, gathering evidence they have used and hope to continue using against Mr. Combs. Now, this disturbing conduct is a blatant violation of Mr. Combs' rights. Prosecutors say the search was motivated by security concerns at MDC, but that is a false pretext. Now, remember, I told you guys that was a false pretext, okay? I told you guys from day one that when they went there with that interagency operation, where they went in there talking about they're looking for contraband and all that, I told y'all that was all BS. They were targeting Diddy, okay? So please pay attention. Now, the purported purpose of the BOP sweep was to search for contraband, but since when is prison contraband photographed and left in place? If it were contraband, it would have been seized. That is not what Investigator 1 did here, leading to the inescapable conclusion that this was an intentional, targeted, and illegal search to discover any information that could give the prosecution a leg up against Mr. Combs, including his handwritten privileged notes, a roadmap to his defense. That an investigator working with the prosecution team specifically to investigate Mr. Combs at the end and the MDC would use a multi-agency search of the facility as a ruse to surreptitiously spy on Mr. Combs' defense camp is outrageous. Are y'all hearing this? No legitimate penological interest motivated this conduct. Now, if the government is seriously contending otherwise, it should call to the stand the lead official from the U.S. Bureau of Prisons or whatever agency was in charge to explain how this unlawful, targeted actions that violated an inmate's 4th, 5th, and 6th Amendment rights were contemplated by and within the purview of the BOP sweep at MDC. Honey, they're not playing games. Listen to the legal jargon, honey. This is all very thorough as far as I'm concerned. Now, the government's illegal actions do not end there, however. Immediately after the search, Investigator 1 debriefed the prosecutors. They had a clear opportunity to remedy the misconduct, but instead they doubled down. The prosecutors knowingly, intentionally, and secretly took possession of the notes and then used them against Mr. Combs. They took the notes without following the agreed upon filter team procedure that is supposed to ensure that the case team is not tainted by access to privileged information. Then they appended clearly privileged portions of the notes to their bail opposition to support continued detention. And it is possible to know what else the government has done with the notes. Indeed, the prosecution has refused to disclaim using the notes to further its investigation going forward. This entire sequence of events, even based on the facts known to date, is shocking and outrageous government conduct. The government has intentionally violated Mr. Combs' attorney-client privilege and Sixth Amendment right to counsel by invading the defense camp and unjustifiably interfering with his relationship with counsel and his ability to defend himself. And then they reference a case, United States versus Stein, okay, a Second Circuit 2008. So they've got a case that sets precedent. Please pay attention. Mr. Combs cannot possibly receive a fair trial if he is not permitted to confer privately and confidentially with his counsel and others working at their direction, and to take and keep notes of his trial preparation. The search also violated the Fourth Amendment and Mr. Combs' Fifth Amendment due process rights. Now, this court's intention is imperative to safeguard Mr. Combs' constitutional rights and ability to defend himself against these very serious charges, because the government has proven time and time again that it will intentionally continue to violate these rights if given the chance. Now, this is the same prosecution team that provided doctored and misleading CNN videotape to 3 judges while withholding more accurate footage to keep Mr. Combs in jail. This is the same prosecution team that seeks to distance itself from Homeland Security agents who leak false and damaging statements to the press. This is the same prosecution team that has repeatedly alleged that a second woman was a sex trafficking victim without having even spoken to her. And now they are deploying Big Brother tactics and an illegal search of the defense camp. This presents or represents the office's tradition of doing the right thing the right way for the right reasons. Then Mr. Combs' only chance at a fair trial is immediate judicial intervention. Honey, she is going in, honey. Okay, please pay attention. She seems to be a whole lot more thorough than Mr. Mark Agnifilo. Request discovery and a hearing to determine the extent of the violations, to establish procedures to minimize prejudice going forward, and to ensure that Mr. Combs receives a fair trial. The court should also order other necessary relief, including but not limited to: 1, suppression of the notes and any fruits of the illegal search. Okay, didn't I tell you guys they were going to be doing that? Because I told you from day one that it was fruits of the poisonous tree, if in fact they did take any of his notes that had privileged information between he and his counsel. 2, directing that a special master conduct privilege review in lieu of the filter team going forward. And 3, disqualification of any and all prosecutors tainted by access to the privileged materials. 4, ordering the government to stop monitoring Mr. Combs' communications with the defense team. And 5, depending on the evidence adduced at the hearing, dismissal of the indictment. Do y'all hear this? Do y'all hear this? She said, depending on the evidence adduced at the hearing, dismissal of the indictment. And adduced is a legal term and basically means brought forward. Okay, so the evidence brought forward at the hearing, depending on what evidence they get when they have the hearing, honey. This is all nefarious. Now, Investigator 1's investigation of Mr. Combs. While Mr. Combs has been detained at the MDC BOP staff, including Investigator 1, have consistently, let me read that again. While Mr. Combs has been detained at MDC, BOP staff, including Investigator 1, have consistently monitored the defendant's communications on monitored communication channels. Now, throughout these monitoring efforts, Investigator 1 was focused on Mr. Combs in an investigatory capacity, as he was tasked with reviewing the defendant's calls and emails. The government was particularly interested in Mr. Combs' communications as part of what it describes as a continuing, ongoing, covert investigation into the defendant's obstructive conduct in the MDC. It therefore requested materials from Investigator 1, who turned over materials, including Mr. Combs' calls and emails, in response to grand jury subpoenas and document requests. Now, from October 28th to November 1st of 2024, the BOP conducted a sweep of the MDC. It was purportedly pre-planned and coordinated as part of a larger safety and security initiative and not in response to any particular threat or intelligence. The prosecutors knew in advance that Mr. Combs' unit would be searched during the sweep. The government's representation of what occurred during the sweep, which Mr. Combs disputes, is as follows. Investigator 1 was assigned by BOP to participate in the sweep and was present at the MDC during the operation. The government claims that during the sweep, Investigator 1 interviewed multiple inmates, including Mr. Combs, about potential corruption and contraband at the MDC. Investigator 1 then searched Mr. Combs' area for contraband. He found none. He then encountered a manila folder marked blank, as well as an address book and several legal pads that the government characterizes as a single blank. According to the government, Investigator 1 set aside the manila folder and then reviewed and photographed the blank, notwithstanding the fact that the photographs clearly reflect pages from at least 2 legal pads as well as stray pages. There are 19 photographs, 10 of which depict Mr. Combs' legal pads. Notably, the government's story diverges in significant respects from the defense's understanding of events. First, it is not clear to the defense that Investigator 1 is actually an MDC employee. For example, the assistant warden at the MDC has since represented that Investigator 1 is not anyone under his command, and the agent who interviewed Mr. Combs during the sweep was not based in New York. Second, the notes at issue were not stored on Mr. Combs' bunk, but were stored in his locker, meaning the government's description of the chain of custody of the notes is incomplete or inaccurate. And finally, the defense has been told by BOP guards at MDC that they do not carry cameras or cell phones, and it is not usual policy or procedure to do so or take photographs such as the ones taken by Investigator 1. Now, I want you all to pay attention because that's important. That's absolutely important right there, because if it is not in their practice or policy to walk around with cameras or cell phones and to take photographs, then why did they do it in this case? Who put them up to it? Was the prosecution behind it? Did they do this at the prosecution's behest? Because that's what it's sounding like if what Ms. Shapiro is alleging is in fact true. Okay, I want you all to pay attention. Okay, Mr. Troy said they gonna lose. They lying. Yes, they do. This is real crazy. And TC Dan said this is not looking good. Okay, because why are they doing these things if this is in fact true? Why are they doing these things that are not in compliance with what they normally do? Or this is not the policy of how things are usually run. Okay, if they're not. First of all, it really doesn't make sense to take pictures of something that you might consider to be contraband, but then you don't take it in your possession. So if you didn't take it in your possession, then clearly it wasn't contraband, as she says. Okay. And then why did you have a camera or a cell phone or whatever he used to take these photographs if that is not the policy, if that's not the norm? Now, goes on to say the government's description also lacks critical details. For one, the legal notes at issue are not limited to the notes Investigator 1 successfully photographed. Rather, among the stack of legal pads were other papers that Investigator 1 I would have seen papers that would have given Investigator 1 a preview into Mr. Combs' entire defense strategy, his thoughts and impressions regarding the evidence and charges, and other classic examples of work product. Investigator 1, for at least one of the notepads, rifled through 7 pages of material prepared at counsel's direction to photograph pages 1 and 2 of Exhibit 1. Now, The government has not described the full extent of Investigator One's communications with them and what, if any, additional privileged material was conveyed. Even if this information was not shared with the prosecution team, it is still known by Investigator One, a government agent working to advance the investigation. The government cannot describe the full extent to which Investigator One might have reviewed but not photographed these other privileged materials and orally shared what he saw on these pads because it knows it could not legally have access to this information. That goes right back to the fruits of the poisonous tree doctrine. According to the government, following the MDC sweep, Investigator One alerted the prosecutors that he had taken photographs of the defendant's blank notebook. Investigator One described its contents, although it is not clear how or to what extent Investigator One shared this information with the prosecutors or which prosecutor specifically. The prosecutors then asked Investigator One to provide the photographs directly to the filter team. It is not clear if the prosecutors subpoenaed the photographs from Investigator One or whether Investigator One simply shared them upon being asked. And then the government requested receipt of those documents. At the time the prosecutors requested the photographs, they understood there was a possibility that they touched on legal strategy and could be privileged. The notes were then shared with the prosecutors after a review by the filter team. The filter team did not withhold any of the materials from the prosecutors, but merely applied a de minimis redactions to certain limited content in the notes, basically saying they just redacted some things, but they still looked at what they wanted to see. Prior to sharing the redacted notes with the prosecutors, the filter team did not provide any copies of the notes to the defense team, departing from the parties' prior practice and agreement. On November 15th of 2024, the government filed its opposition to defendant's renewed bail motion, which stated the trial prosecutors possessed possibly privileged materials, such as the notes recovered from the defendant's cell. The opposition cited excerpts of two such notes, Exhibits E and O. The opposition said the government had listened to Mr. Combs's calls, including with family members and his attorneys, and reviewed his messages with dozens of individuals, including attorneys. Until receiving the government's submission, the defense had never been notified of these facts and was unaware that Investigator One had viewed and made copies of Mr. Combs's privileged materials. Mr. Combs's counsel immediately notified the prosecutors the notes were privileged and sought relief from the court. The court ordered the parties to submit letters in advance of a November 19, 2024 hearing. The government produced copies of the unredacted notes reviewed by the filter team, as well as the redacted versions it received from the filter team. Mr. Combs's counsel submitted an ex parte declaration describing why these materials were privileged. Okay, now, at the hearing, the government argued that the materials were not on their face privileged and stated it intended to use those notes in connection with its ongoing investigation. The court ordered the prosecutors to destroy any copies of the notes in their possession and set a schedule for an instant motion. Okay, I don't know how this is going to go, but I'm tell you like this. Everything that she's complaining about seems to be legit as far as I'm concerned. Okay? Red Wine Entertainment says they want it so bad they can taste it. Mr. Troy on point with the info says they trying to reverse it and make it look like his rights were violated in prison, jail. You have none, only a few facts. Well, here's the thing, beloved. Whether in prison or jail, they're not supposed to be looking at attorney-client privileged information. That's what they're not supposed to do. And if, in fact, it is found that they told this person, what is he called? Investigator One, to go in there and get stuff that they want to see so they can find out so they can have a leg up, as she's clearly implying, that's problematic. Okay, that is absolutely problematic. So We'll just have to wait and see, but it's not looking so good. Now, with that all being said, um, and then another thing is when they say Mr. Combs is, hold on, where am I at? Okay. And another thing is when they say Mr. Combs' counsel submitted an ex parte declaration describing why these materials were privileged, well, they're saying it was basically one-sided. That's ex parte is just like one side. Just like in the case of Young Thug, when they had that ex parte meeting in the judge's chambers and didn't bother to tell Young Thug or his defense counsel. Now, so anyway, it goes on to say the government acknowledged the risk of continuing to rely on the notes in its investigation, but did not agree to refrain from doing so going forward. Now, communications with the prosecutors in this case suggest that the government has already made affirmative use of the notes even apart from its bail arguments. But the full extent to which the prosecution has been tainted by its knowledge of privileged material is entirely unknown. And now they go into the argument where they say the government violated Mr. Combs' attorney-client privilege and Sixth Amendment rights. The government invaded the defense camp to obtain and use materials protected by the attorney-client privilege. Such government interference in the relationship between attorney and defendant may violate the latter's right to effective assistance of counsel and thus the defendant's Sixth Amendment rights. And then they reference United States v. Simons, okay, from 2011. Also, they quote United States versus Ginsburg from 1985. Now, in determining whether the government violated Mr. Combs' rights, the court should consider whether the government intentionally sought to obtain privileged communications and whether those communications were passed to prosecutors in a pending case. And then they reference another case, Weatherford versus Bursey, 1977. Now, this is, and basically for those of you who don't know, when they're citing these other cases, referencing these other cases that have clearly set precedent, what they're basically showing is that this is a problem. You can't do this. It's not how it's supposed to go. And here's a case where somebody tried the same thing and it didn't fly. Okay? So that's what they're basically doing. If anybody's wondering why they keep referencing these other cases, but let's continue. Now, that is precisely what transpired here. Hold on, I think I skipped some. Let me go back a second. Okay, so they say they violated Mr. Combs' rights. The court should consider whether the government intentionally sought to obtain privileged communications and whether those communications were passed to prosecutors in a pending case. So they want to know if they purposely did this, if this was just, if they had ill intentions, if this was, they were being malicious or whatever, or if it was just the fault of investigator one. Maybe he just went and got this information and just gave it to them, or they didn't request for it or whatever. Okay, all that's going to be important. Now, that is precisely what transpired here. Such an intentional intrusion warrants careful scrutiny because it violates the defendant's constitutional rights. So they're saying they did do it on purpose, that they intentionally did all of this. And then they reference United States versus Schwimmer from 1991. Now, it is well settled that individuals retain their attorney-client privilege when incarcerated or detained. Okay, they reference more cases and say, and even when inmates have a reduced expectation of privacy in documents for Fourth Amendment purpose, the Sixth and Fourth Amendment inquiries are independent of each other. So please pay attention because, see, when you say they don't have rights, for the last comment, when you say they don't have rights in jail, that's not true. They still have rights. They may not have as many as they would have in prison, but they still have rights. And specifically, you're going to always have rights to attorney-client privilege. Nobody's supposed to be meddling in on that, period. Now, with that all being said, such memorializations of private conversations an inmate has with an attorney are protected from disclosure by the attorney-client privilege, as is an outline of what a client wishes to discuss with counsel, prepared in advance of any such discussion. Even where the contents of outlines are not subsequently discussed with an attorney, they are protected if they are not conveyed as a consequence of intervening events such as delay. Now, and notes prepared by a client at the behest of counsel in anticipation of litigation are also protected by the work product doctrine. Mr. Combs has already made the required showing that the notes cited in the government's oppositions, Exhibits E and O, are indeed privileged. They contain memorializations of private conversations with counsel, as well as Mr. Combs's outlines for discussions he subsequently had with his counsel. The vast majority, and you all know they're not supposed to be doing this. They're not supposed to know what him and his attorneys are talking about. They're absolutely not supposed to be doing that. Okay. When the attorney goes into a jail, because they're saying they monitored even the phone calls that he had with his counsel, as well as family members. But when a attorney goes into a jail to visit their client and speak with them about their case, there's nobody supposed to be present in the room. This is not supposed to be recorded. It's supposed to be off the record strictly. So the vast majority of the remaining notes are also privileged or work product. Now, the notes reflect trial strategy, opinion material revealing counsel's and Mr. Combs's mental processes regarding his defense, the anticipated course of the defense investigation and questions concerning past investigation, possible trial witnesses and testimony. The notes also reflect Mr. Combs's thoughts on certain avenues of investigation and trial strategy prepared at the behest of his counsel. Because Mr. Combs supports his claim with more that mere conclusory or if dixit assertions in grand jury subpoena dated July the 6th of 2005. This is a case that they're referencing. He has satisfied his burden of showing that the materials in question are privileged. Okay, so here's the thing. At the end of the day, this is really looking like they possibly told investigator one. First of all, the question also is, why is investigator one supposed to be basically monitoring everything that Diddy does and not monitoring what the other people are doing? Are they saying that Diddy is so problematic that they just need to watch him? Okay, at the end of the day, I'm just curious. So anyway, when they talk about, they say because Mr. Combs supports his claims with more that mere conclusory or ips dixit assertions. Okay, then they reference this other case. Now that is legal jargon. It really means made without proof or evidence. Okay, without any proof or evidence is what they're saying. Now he has satisfied his burden of showing the materials in question privileged. That they are privileged. Now, there is no question the prosecutors requested and subsequently possessed Mr. Combs's privileged materials, violating his Sixth Amendment rights. The prosecutors were put on notice of the privileged nature of the material when investigator one alerted them to its existence and described its contents. Knowing it is likely privileged, the prosecutors asked investigator one to share the materials through the filter team, never alerting the defense team that the government was in possession of privileged material. And when the prosecutors ultimately received the barely redacted copies of the notes, it was clear from the face of the notes that they were privileged. Saying that they knew they weren't supposed to be looking at it, okay? That they knew they weren't supposed to have that in their possession or even be looking at any of this stuff. But the prosecutors ignored these clear indications of privilege and affirmatively used the material in their bail opposition. They did so while admitting they were currently in possession of possibly privileged materials. This is a clear violation. Indeed, the Solicitor General has twice conceded that the Sixth Amendment would be violated if the government places an informant in the defense camp during a criminal trial and receives from that informant privileged information pertaining to the defense of the criminal charges. And then they reference the case Weatherford. Okay, so this is, or they quote Weatherford. Now this is interesting because they're basically saying that the Solicitor General has twice conceded that this is something you're not supposed to be doing. Okay, that it's in violation of the Sixth Amendment. If you have an informant, which that's clearly what investigator one is, he's an informant. Okay, he's telling them what's going on. He's monitoring what Diddy's doing. And if that informant during a criminal trial and receives from that informant privileged information pertaining to the defense of the criminal charges, that's what you're not supposed to do. So they're implying that not even implying, they're flat out saying that this investigator one is an informant and got this information and reported right back to them, which he wasn't supposed to do, is what they're saying. Now, the fact that legal strategy was conveyed not just to government agents, but to the prosecution team distinguishes this case from other cases. In United States v. Arrington, for example, the FBI agents did not review the papers, but instead gathered the papers for standby counsel's later analysis, never communicating anything from the defendant's papers to the prosecution's team. And in Weatherford, there was no communication defense strategy in the prosecution. Okay, so, but here, the prosecutors affirmatively requested the material and then used material that was on its face clearly privileged. Now, the way the prosecutors diverged from the agreed upon filter team protocol is further evidence of misconduct. Under the usual agreed upon protocol, the defense should have been notified that the government possessed possibly privileged materials and been given an opportunity to view the materials and assert privilege. Instead, however, the prosecutors bypassed this protocol and the filter team simply passed most of the material on to the case team. And again, they cite more cases to prove their point. Nor was this an instance in which the prosecutors received after the fact notice of potentially privileged documents or acted pursuant to a search warrant subject to judicial oversight. Now, rather, the prosecutors understood the privileged nature of the documents up front, yet proceeded unilaterally and without caution with the goal of taking advantage of their improper access to privileged material to keep Mr. Combs detained and try to obtain a conviction. There is no excuse for this blatant disregard for Mr. Combs' Sixth Amendment rights. Well, I mean, I'm sorry, but they have points here. Okay, they have valid points at the end of the day. Now, the Fifth Circuit's United States v. Brown decision is instructive. Okay, and this is a case from the Fifth Circuit in 1973. Although the court rejected the argument that an undisclosed government overhear of an attorney-client conversation required a new trial. Are y'all listening to this? Okay, it did so only because there was no indication that defendants' telephone conversations were monitored for the purpose of gaining information to use at his trial. And the surveillance was neither authorized nor approved by federal authorities. The court made clear, however, that in cases like this one, where those were the facts, it would amount to a practice it would immediately prescribe with appropriate remedy, including retrial. Okay, see, this is what I'm talking about right here. This is all crazy. The feds, like I told you guys, I'm starting to wonder, and I've been wondering, are they doing this on purpose? Okay. Now they're talking about a case like this before where something similar was done. It called for a retrial. And didn't I tell you guys, okay, Diddy could be asking for, even if he gets convicted, he could ask for an appeal because saying that he had ineffective counsel, that he wasn't allowed to have effective counsel. That's the main reason why people filed for an appeal, just so you know. And they've said that more than once throughout this document, that they're not able to provide effective counsel. So goes on to say, of course, the Second Circuit shares the view that a surreptitious intrusion by a government agent into the confidential relationship between lawyer and client and other similar tactics are beneath the high standards of professional conduct expected of government counsel. And then they state another case. Now they go on to say now that the government violated Mr. Combs' Fourth Amendment rights. Now they've already proven their case for the Sixth Amendment as far as I'm concerned. Okay, I'm sorry, but they look like they have the prosecution dead to right. Now we'll find out further when they have this meeting or this hearing that they're demanding. So the search and seizure of Mr. Combs' notepads also violated the Fourth Amendment. Pretrial detainees retain Fourth Amendment protections, and a pretrial detainee's loss of Fourth Amendment rights is occasioned only by the legitimate needs of institutional security carried out by objective administrators. And then they reference another case. Now, and here's the thing. See, when they're referencing these other cases, like I told you, this just means that this has already been a no-no before, okay? This has already been something that's been a problem before, and they didn't get away with it, okay? So warrantless searches performed at the instigation of non-prison officials for non-institutional security related reasons are thereby prohibited by the Fourth Amendment. Likewise, warrantless searches intended solely to bolster the prosecution's case against a pretrial detainee awaiting his day in court or to uncover information that would aid them in laying additional indictments against the detainee are out of bounds. Now, why is that a problem? Because remember, it was because of these notes that they had that they basically knew that Diddy had talked to certain people and that Diddy had wanted his children to put out that video and all of that, which they claimed was obstruction, and and that he was trying to garner sympathy or whatnot. And so then it goes on to say, where such a search is performed, the validity of the search may be challenged. The suppression required if the search was not conducted for legitimate security reasons. Federal courts charged with a duty to protect these rights do not fulfill that obligation merely by paying lip service to this concept. Not lip service, honey, she is going in. Are y'all paying attention? Now, this was plainly no legitimate security reason to peruse Mr. Combs's personal notes or photograph them. The government admits Investigator One's aim was to uncover information that would aid the prosecution of this case and gain a tactical advantage. So Investigator One has already admitted to this, okay, according to what she's saying, that Investigator Number One has already just said, yeah, that's what it was. I went in there and I took those photographs, and it was all to uncover information that was going to help the prosecution, okay, and to help them gain a tactical advantage. In other words, to give them a leg up on the defense. The state rationale for the BOP sweep was to find contraband and evidence of MDC corruption. But the search quickly progressed beyond that limited purpose and became a pretext for an unconstitutional search. No contraband could possibly be found in the pages of Mr. Combs's notes, yet Investigator One searched them anyway. And he did not stop merely at searching the notes. He then photographed multiple pages of the notes so he could share them with the prosecutors. It all sounds malicious, guys. Please pay attention. Nor was the search carried out by an objective administrator. Instead, it was carried out by a biased investigator collecting additional evidence for the prosecution team. Indeed, the government admits the materials were ultimately received as part of a continuing covert investigation, the goal of which is to produce evidence supporting additional criminal charges against Mr. Combs. At the time of the search, Investigator One knew the materials would be useful to the prosecution, photographing the notes for that very purpose, and not because of any institutional security concerns related to the BOP sweep. So they said he knew exactly what he was doing. That's the sole purpose of him photographing that stuff, was exactly so he could help the prosecution. It didn't have anything to do with the sweep, the looking for contraband, or any type of investigation that the interagency operation was pertaining to. It had nothing to do with that, is what they're saying. It is no response for the government to pretend Investigator One is not a member of the prosecution team. Okay, in other words, and y'all can stop lying. Okay, y'all can stop playing games. At the end of the day, he's absolutely a part of y'all's team, so just stop it. Okay, the Fourth Amendment proscribes unlawful searches by government actors. Okay, then they reference the case United States v. Jacobson, 1984, saying even if Investigator One was not working at the prosecution's direction, he was clearly a government actor. Regardless, it is undisputed that Investigator One performed investigative duties on behalf of the prosecutors. Investigator One was specifically tasked with consistently monitoring the defendant's communications, and he was focused on Mr. Combs in an investigatory capacity, okay, as he was tasked with reviewing the defendant's calls and emails. He did this on behalf of the prosecutors and pursuant to their continuing request to collect evidence as part of the government's ongoing investigation. He thus monitored communications, identified helpful evidence, and produced it to the prosecution team. He did that prior to the BOP sweep. Wait a minute. Say what now? He did that prior to the BOP sweep and acted with that purpose during the sweep, which is why he immediately voluntarily alerted the prosecution or prosecutors that he photographed materials written by the defendant, including notes regarding finding dirt on witnesses. Okay, here's the thing. Now, I don't know how I missed this or if this has even been alleged before, but she's clearly saying that investigator one went in there and did some of this stuff before they even conducted the BOP sweep. So no, y'all can't even try to sit there and act like investigator one. This is what she's saying. Of course, I'm paraphrasing, but basically saying y'all can't even sit there and try to play these games and act like investigator one was only in there because of the interagency operation that was going on, because he did this before they even got there. And then he went and alerted them. The prosecution didn't come and ask him. He voluntarily alerted the prosecutors that he had photographed the materials, and then talked about Diddy saying something about getting dirt on witnesses. So they can't use any of this. If this is all true, they won't be able to use any of this in court. It's fruits of the poisonous tree. So with that all being said, moreover, upon being alerted of investigator one's conduct, the prosecutors immediately ratified it by debriefing him about the contents of the notes and asking him to produce them. Even if they did not order the search ex ante, they endorsed investigator one's unlawful conduct and used it to further their investigation and detention of Mr. Combs. So basically saying that they had no business even using this to try to keep him from getting his bail. And even though they may have had legit reasons to prevent him from getting bail, like maybe he was a threat, okay, maybe he's obstructed before, as they were saying, but at the end of the day, they're just saying, they didn't have any reason. They weren't supposed to be allowed to use this. Okay, this is all so crazy. And so anyway, when they talk about let me go back just a second. Even if they did not order the search ex ante, they endorsed investigator one's unlawful conduct and used it to further. Now, when they say ex ante, they're basically talking about this was based on forecasts or things that they would foresee, not actual results, things that they were just estimating, that could be the case, not actual events. This is all nefarious. Please pay attention. So then goes on to say discovery and a hearing are required. See, now they want a whole nother hearing, okay, to get to the bottom of this, to find out what really happened. And then they want investigator one to testify at that hearing. Mr. Combs's rights were clearly violated. As explained below, the appropriate remedy depends on the government's intent, investigator one's motivations, and the extent to which the privileged material has been used to develop the government's investigation. A hearing is necessary to determine these issues and to resolve disputed factual issues. For example, the government claims its review need only be reasonable, not perfect, and said it's proceeded here in good faith. But that claim is belied by its insistence, at least prior to the court's intervention, on continuing to use the materials to advance its investigation and prosecution. And the government's account of what happened conflicts with basic information the defense has learned. A hearing is required to find out what really happened and why. So they're accusing the feds of doing illegal tactics and lying. Okay. The court should not, it's like they're putting the feds on trial. Now they want a hearing and they want investigator one to testify and all of this. They want to get to the bottom of it because they absolutely think that they're lying, or maybe they know they're lying. So goes on to say the court should not just accept the government say so. Okay, they need to bring receipts, is what they're saying. No, we're not just going to go by what they said. They could say anything. Why would they admit that they were dead wrong and that they lied and that they did illegal tactics to gain information to help their case and to further hinder Diddy's defense? They're not going to admit that, is what she's saying. So we can't just go by what they're saying. No, we need proof and receipts. We need a thorough investigation. And this is why we're calling a hearing. That's basically what she's saying. So she said we shouldn't go by, the court shouldn't accept the government's say so, especially because the government's narrative does not ring true. calling them liars. Now, moreover, while the government says it didn't specifically direct Investigator 1 to search Mr. Combs' notes in advance of the raid, its conduct after he alerted them to the material suggests this could simply be part of an effort to distance the prosecutors from conduct they knew they couldn't legally participate in. And that's likely what they did, y'all. This is likely what they did. The prosecution thinks they're so slick and sly. This is likely what they did. I mean, it all makes sense. Okay, they probably did have Investigator 1 go in there and do this stuff prior to the raid happening, and then just tried to distance themselves to say, so they could later say in court, if it was a problem like it is now, they could say, well, we didn't tell him to do that. We didn't know he was going to go in there and take pictures of those notes. We didn't have anything to do with it. We just told him to monitor the communications like the phone calls and the emails. We didn't tell him to go in there and do any of this stuff. So that's not our fault. Now, I thought of himself, I'm sorry, as the court noted, it is impossible. Investigator 1 thought of himself as an agent of the prosecution's team. If so, why? Is that because of the history of their prior communications about the government's continuing investigation? Was there a tacit understanding that he should do what he could to help the government develop evidence against Mr. Combs at any opportunity? See, they have several questions, as do I. Now, who is Investigator 1? And whose instructions was he following? Okay, the court should order the government to produce Investigator 1's communications with the prosecutors. Now we want to know, since they want to know what we're talking about with our client, since they want to know what we've shared with our client, now we want to know what the hell they've been saying to Investigator 1. We want to see their communications so we can find out exactly what went down, so we can see for ourselves what was really said. We're not going to take their word for it. This is what they're saying. So goes on to say, who is Investigator 1 and whose instructions was he following? The court should order the government to produce Investigator 1's communications with the prosecutors, take his testimony to fully understand what he was thinking during the search, and explore whether the BOP sweep served as pretext for his targeted search of Mr. Combs' materials. And the word saying, did y'all just set this all up? Was this a whole setup? Did y'all really sit up here and have this interagency operation where they came in and conducted a sweep just so Investigator 1 could have an excuse for why he was illegally gathering information against the defense and Diddy for the prosecution? Is that what y'all were doing? This is what they're trying to find out. This is all nefarious. Please pay attention. Please pay attention. Now, and if they did have that search conducted just for that specific region, which I absolutely believe they did, because I told y'all from day one, I said after all these years that people have been complaining about this facility having, contraband, or this talking about drugs being smuggled in and all this stuff that they've been complaining about for years. Now, all of a sudden, that Diddy's there. They want to go in and conduct a sweep. I told you guys that Diddy was the target. But of course, I thought it was something much more nefarious. So they could possibly try to Jeffrey Epstein him or something, or try to figure out how they could. That's what I was thinking. But nonetheless, I knew that this was all pertaining to Diddy. So they can sit down somewhere, because this is all coming out in the wash. Okay. This is just like I told you guys, the prosecution just keeps making a bunch of fumbles and bumbles. And it's just all getting real annoying, because they're going to mess right around and Diddy's behind's going to get them out of there. Okay. Please pay attention. Okay. And all these liars going around lying and making up stories and from movies and all of that, acting like they were victims and this, that, and the third. That's not making it any better. But let me continue. So goes on to say the court should also order disclosure of any video footage of the search to test whether the government's description of the events is accurate. Ooh, honey, they want receipts, okay? We want to see the video footage, because how do we know that what they're saying is in fact even accurate? They could be sitting up here and lying, which is probably, unfortunately, what they're probably doing, in my opinion. Now, the court should take testimony of Investigator 1 and whomever else was involved to determine which notes, papers, and materials were reviewed. We should learn whether Investigator 1 worked alone or if others were involved. Did investigator one use his personal cell phone to photograph the materials, or what did he do with the photographs? Did he send them to anyone else? Was investigator one in contact with anyone from the Department of Homeland Security prior to him photographing those notes while he was doing so, or afterward? Did investigator one ever report to the official supervising the sweep that he was photographing Mr. Combs's notes? Did he provide the photographs of the notes to his supervisors? If this was really part of the established protocol, one wouldn't expect that he in fact did. Or did he only provide them to the U.S. Attorney's Office? Who at the U.S. Attorney's Office knew that he was giving them photographs of Mr. Combs's notes? Who approved this? Oh, honey, she has a whole lot of questions. And now so do I. This is all getting real nefarious real quick. Okay. And before weighing the prosecutor's claims that they acted reasonably after being alerted, the court should hear testimony and order discovery of any emails, texts, or other communications regarding what exactly the prosecutors knew before requesting copies of the notes, whether any context was communicated to the filter team before the filter team conducted its review of the notes, whether the filter team even understood where the notes came from, why the notes were not shared with the defense team in accordance with filter team protocol and Fed or CRIMP, and who else the government shared the notes with, including possible witnesses or alleged victims. This is all critical to assessing the government's intent, Your Honor. Oh, honey, are y'all listening? Because this is all nefarious. This is all nefarious as far as I'm concerned. Okay, please pay attention. All right, this is all nefarious. At the end of the day, this woman has got her stuff together, honey. She is good. She is a whole lot more thorough than Mark Agnephilo. Okay, I want y'all to pay attention, honey. She is standing on business. Okay, I'm sorry, say what? This woman is absolutely standing on business. Are y'all paying attention? Are y'all paying attention? This is all nefarious. Okay, let me see what y'all talking about. All that, and he still will be going to prison, says Southwest Houston Tech. Says you can't outrun karma and balance. Those scales will balance. Honey, I hope so. Okay, you know I hope so, honey. Don't y'all let Diddy mess around and get up out of here, honey. Oh my goodness, that would be just tragic. Okay, please pay attention. Please pay attention, but let me continue. And so whether the filter team even understood where the notes came from, why the notes were not shared with the defense team in accordance with the filter team protocol. So with that all being said, when investigator one took that stuff to the prosecution, it was also supposed to be shared with the defense. Okay, so that's problematic in and of itself. Okay, that is problematic in and of itself. In accordance with filter team protocol and which is Federal Rule of Criminal Procedure, okay, 16. That's what that stands for. But who else the government shared the notes with, including possible witnesses or victims? So basically, they're now trying to say that we don't know who the hell they showed this stuff to. The prosecution or investigator one, we don't even know who investigator one is, who he was working for, who sent him to do this, who sent him. Okay, and who else did he give this to? And is it still on his cell phone? Did he use his cell phone to take these photographs, or did he use an actual camera? And if so, where is the footage? Okay, does he still have this stuff on his cell phone where anybody can see? This is a whole nother can of worms, because they're going to have to answer for all of this when they have that hearing. And she says this is all critical to assessing the government's intent. It absolutely is. She's not lying. A hearing is particularly necessary because the government's description of the events does not align with the defense team's understanding of what transpired. As explained, it is not clear who investigator one is or why he was participating at the MDC sweep. The government's representation that investigator one encountered the notes on Mr. Combs's bunk and that there was no indication the notes were privileged is in dispute. And the court, because he said it was on the bunk, but they're saying it was in his locker. Now, and the court should more fully understand what exactly investigator one reviewed, not merely what he photographed, given that he remains enmeshed in the government's ongoing investigation, but has been given a preview into defense strategy. Okay, then they reference United States v. Arrington. Okay, there the defendant argued, and this is what they're saying about that case. The United States v. Arrington is instructive. Okay, basically saying this gives you instructions of what to do in such a case. They say there the defendant argued his rights were violated during a similar search of his prison cell. So this is like the same case or similar to the case of Diddy. Okay, so in this case of the United States v. Arrington, they say the defendant argued his rights were violated during a similar search of his prison cell. The court ordered a hearing complete with testimony from agents involved in the search concerning the chain of custody of the papers taken from the defendant's cell and concerns regarding a review of privileged attorney-client communications and defendant's work product. The government voluntarily produced video footage of the search before the hearing when the court considered in weighing the testimony. And so that's likely what they're going to do. The prosecution may do just that as well. They may just voluntarily give up the surveillance footage rather than going through the embarrassment of this hearing if, in fact, they are not being 100% truthful in their response. So they list all these other cases. Now, remanded from a hearing on whether government agents deliberately intercepted telephone consultations between the defendant and her lawyer before and during the trial. Okay, so this is what happened in another case. Now, the court must also assess whether the government's investigation itself and the prosecutors have been tainted by the unlawful search. Defendant may request a hearing to determine whether information derived from privileged sources was used by the government in violation of attorney-client privilege to prepare for trial. I'm guaranteeing you that's what they did. I'm sorry, y'all, but that's probably what they exactly did. And then again, they reference more cases. They say the district court should have conducted an evidentiary hearing to determine whether the government's case was in any respect derived from a violation of the attorney-client privilege. The court should consider what fruits, if any, were obtained from information seized. Again, the government has likely already made affirmative use of the notes, even apart from their use in the government's bail arguments. So basically saying that, hey, hold on, wait a minute here. Not only have they used this for the bail hearing to prevent him from getting a bail, but also they're likely using this to build their case against him and to, help further their case and even get more charges. Pensilola said, missing the queen in Loyal Royals listening. Thank you, beloved. Okay, thanks for your contribution to the channel. I appreciate you. Peace, love, and blessings. Leon says, all their hands are dirty. Well, it sounds like it. Jamie said, crazy. Oh, so crazy. Absolutely it is. But see, I told you all that these prosecutors were just doing a bunch of BS. I told you guys. This is all what it sounds like. Okay, now a hearing is required to learn the extent to which the prosecution team used the privileged notes to develop leads or uncover new evidence. What other information the prosecution team learned from investigator one, and whether that information led the prosecution team to develop new leads or gather new evidence. What other information investigator one learned, and whether investigator one used any privileged information to develop new leads or gather evidence. I think I read that already. Now, whether the privileged information was conveyed to anyone else, and whether any other government agent used that information to develop new leads or gather new evidence. Okay, they're just being repetitive. Okay, so with that all being said, now they get to this point. This court should order appropriate remedies, use and fruits suppression. So even without further fact-finding, it is clear that the government violated Mr. Combs' Fourth and Sixth Amendment rights. Okay, that's it. Basically, even if we don't find out anything else, we already know and have shown and proven that they violated his Fourth and Sixth Amendment rights. The government conceded that if the notes are indeed privileged, the immediate remedy would be to suppress the government's use of those notes. Okay, that is true. Indisputably, when the government obtains access to defendants' documents, the government is not entitled to rely on privileged materials contained therein. And then they reference more cases. To the extent that the files obtained were privileged, the remedy is suppression and return of the documents in question. She did her homework, is all I'm saying. It is clear the notes are privileged where the product of an unlawful search and must be suppressed. But the government also suggested that it could continue to use the contents of those notes in its ongoing investigation. It refused to disclaim reliance on the substance of what it learned from this illegal search. Okay, so basically saying that the government already let them know, honey, we're going to use this stuff anyway. We don't care if it was illegal. We don't care if we violated Fourth and Sixth Amendment rights, honey. At the end of the day, we're still going to use this to further our investigation, okay, and to get more evidence on Diddy. That's basically what she's saying, that they've already said, and they refuse to disclaim reliance on the substance of what they learned from this illegal search. Now, you just can't do that. Okay, that's not how the law is supposed to work. This sounds to me like prosecutorial misconduct, and they haven't even made it to court yet. Okay, please pay attention. Now, it goes on to say the government thus took the position that while the notes themselves could not be used against Mr. Combs, it could continue to use the fruits of the search against him. This is wrong as a matter of well-settled law. A violation of the Fourth Amendment requires suppression not only of the immediate object of the search, but also any other evidence obtained because of the search. So basically saying, here's the thing. So they're talking about how they got these notes and stuff, and they're saying, okay, so we can't enter the notes in as evidence. We can't show the notes, literally show the notes in court, during the trial because it's fruits of the poisonous tree. This is what the prosecution is saying, basically, according to her. But what they're saying is, okay, we can bring these notes in and use it, but guess what? We can use what we read in the notes. We can use the fact that we read in the notes that he was trying to gather dirt on victims and witnesses. We can use that against him. We may not be able to bring these notes in and show them as exhibit A, B, C, or 1, 2, and 3. But what we can do is take whatever we found from those notes and use that against him. That's what they're basically saying. Now, a violation of the Fourth Amendment requires suppression not only of the immediate object of the search, but also any other evidence obtained because of the search. Now, in other words, the exclusionary rule applies not only to the direct products of unconstitutional invasions of defendants' Fourth Amendment rights, but also to the indirect or derivative fruits of those invasions. Saying, listen, okay, she's saying, no, you can't not only not use the notes, but you can't use anything that you got from the notes. Anything that you read in those notes, you can't use that either. Now, what is true for Fourth Amendment violations is also true of Sixth Amendment violations. When the government interferes with the defendant's attorney-client privilege, it must take care to refrain from affirmatively making use of the interference. The government must follow the procedure set forth at Castigar versus United States. It must demonstrate that the evidence it uses to prosecute an individual was derived from legitimate, independent sources. Okay, not something they got during an illegal search. So applying Castigar framework and holding that the government must prove its evidence was not tainted by the privilege violation and was derived from a legitimate independent source. Then they cite the case United States v. Mastroianni, now from 1984. Thus, it is not enough to suppress the notes themselves. All fruits of the illegal intrusion must also be suppressed, and the government has an ongoing obligation to demonstrate that it made no use of the information obtained by the illegal search. The government cannot, for example, use the information obtained from the notes to seek additional charges against Mr. Combs or conduct additional searches. That's what they can't do. Evidence seized during an illegal search should not be included in a warrant affidavit. It is troubling that the government has already suggested that it may do so. Because basically, they're saying they're going to do what they want to do, honey. Right? Rules be damned. Okay? That's what they're basically saying. Forget the rules of criminal procedure 16 and 23. Okay, we're going to do what we want to do. That's what they're basically saying because they know they can't do that. And that's just not the rules. Okay? Appointment of a special master is what they're talking about. Now, this court should also bar further use of the inherently flawed taint team procedure. It should instead appoint a special master to resolve privilege issues. The government noted at the hearing that several district courts in this circuit have approved the taint team procedure. That is true. What the government failed to note is that a growing number of courts around the country have rejected the procedure for the simple reason that government lawyers have proven they cannot be trusted to protect criminal defendants' privileges. Say that they're just sitting up here doing shady stuff, that they're not to be trusted, okay? Basically saying that they'll do anything and everything to get a conviction. even if it's in violation of the defendant's rights. That's what she's saying. Now, as the Sixth Circuit has held, taint teams present inevitable and reasonably foreseeable risk to privilege, for they have been implicated in the past in leaks of confidential information to prosecutors. Okay, and then they go on to say in Ray grand jury subpoenas, okay, 2006. So, and that's basically talking about the grand jury, of course. Now, while a taint team may have an interest in protecting privileges, it also possesses a conflicting interest in pursuing the investigation. And human nature being what it is, occasionally some taint team attorneys will make mistakes or violate their ethical obligations. The procedure has insufficient checks to correct government mistakes, whether honest or otherwise. So basically saying, listen, okay, they could sit here and act like it was an accident, or they could just later say, well, we didn't know we did anything wrong, or we didn't feel like it was a problem, whatever. But at the end of the day, none of that matters. Okay, the bottom line is they can't do it. All right, so that's what she's saying. In short, under a taint team procedure, the government's fox is left in charge of the defendant's hen house. Are y'all listening? This is an excellent analogy as far as I'm concerned, honey. She said, in short, under a taint team procedure, the government's fox is left in charge of the defendant's hen house and may err by neglect or malice as well as by honest differences of opinion. The Sixth Circuit thus ordered the district court to employ a neutral special master instead, because they can't be trusted, is what she's saying. We can't trust you all. We know you're probably trying to do something shady. You've already alluded to the fact that you're going to use the information anyway, even if you can't use the notes in court. But at the end of the day, we need a special master to come in and step in, someone to intervene and mediate, because we don't know what y'all are up to, but it's clearly something nefarious as far as we're concerned. Now, other courts have similarly noted that taint teams are inherently insufficient to protect the defendant's rights. The Fourth Circuit has held, for example, that when a dispute arises as to whether a lawyer's communications or a lawyer's documents are protected by the attorney-client privilege or a work product doctrine, the resolution of that dispute is a judicial function. Okay? And so that function cannot be delegated to the executive branch. Like the Sixth Circuit, the Fourth noted that it is highly problematic to allow other prosecutors to make determinations about an adversary's right to privilege, citing recent blunders. Okay, it concluded federal agents and prosecutors rummaging through materials that are protected by attorney-client privilege and the work product doctrine is at odds with the appearance of justice. This is also interesting. Now, more recently, the Fifth Circuit noted that the government's use of a taint team had resulted in a callous disregard for a criminal defendant's rights. And then they cite another case. They say that the privileged material was obtained through a valid search warrant did not justify the government's conduct, nor did the existence of secret ongoing grand jury proceedings. Okay, now the Fifth Circuit held that all potentially privileged material must be immediately returned, that is not held for a filter team, and that going forward, the district court should engage a magistrate judge or special master to review the potentially privileged documents. Engage a magistrate judge or special master. Okay, so basically when they have this hearing, if they do have one, they don't want the same judge, Judge Subramaniam. They want a special master or a magistrate judge is what they're basically saying. Many district courts around the country have likewise questioned the taint team procedure. And then they cite a myriad of other cases. The cases above recognize that in general, the use of a neutral arbiter, such as a special master, is more likely to protect a defendant's rights than the use of a prosecutorial taint team. And whether the general merits of the taint team procedure, the filter team is in this case utterly failed. Now, despite seeing references to defense experts, paralegals, witnesses, cross-examination strategy, and even names of defense lawyers, it failed to mark the material as privileged. It is inconceivable that a taint team attorney identified obviously privileged communications on a page, marked it as such, and yet did not recognize the remainder of the page referencing lawyers and paralegals are also as privileged. Now, the taint team has proven itself to be completely incapable of performing the most basic privilege review. So, not necessarily saying they want another judge, but saying that basically the taint team They don't want them to be in charge of this. They don't want them deciding on anything or whatever. So moreover, where courts have approved the use of taint teams, the government typically seeks court pre-approval of its filter team protocol in an adversarial context or an informal good faith resolution with the defendant. Now, in this case, and they cite another case, in this case, however, the government neither sought court pre-approval of its filter team protocol in an adversarial setting or nor engaged in good faith informal negotiations with the defendant about the creation of a protocol. Now, to the contrary, the government simply created its own rules, saying they're just doing what they want to darn do, okay? They're just making up the rules as they go and whatever suits them. Departed from the party's previous practice and understanding. Predictably, the result was a disaster. The filter team handed over obviously privileged material to the case team in barely redacted form. In other words, this is not a case where the filter team did its work carefully and thus successfully hid privileged materials from the case team. Okay. Prosecutors successfully screened. And then they reference Arrington of 2022. FBI agents did not communicate anything from the defendant's papers to the prosecution team. The filter team failed to do its job and violated Mr. Combs' rights. There is no reason to think that it will do better going forward or that the case team will call its fouls when it errs again. This court should appoint a special master. Dismissal of the indictment. Now, here's the part right here. Okay, based on the information already known, it is clear the government has violated the Sixth Amendment by intruding on the attorney-client relationship and interfering with Mr. Combs' relationship with counsel and his ability to mount the best defense that he can muster. This extraordinary violation of Mr. Combs' Fourth and Sixth Amendment rights also constitutes outrageous government conduct that violates his Fifth Amendment rights to due process. Dismissal of the indictment may therefore be warranted upon development of the full factual record at a hearing. Dismissal is appropriate not only where the conduct of the government has been manifestly and avowedly corrupt. Calling them corrupt, honey, I want y'all to pay attention. They said the government is corrupt in their practices. They have lied. They have engaged in illegal tactics to gather information on Diddy. They have targeted him. They are basically saying they want a dismissal due to all of these issues. Okay? Dismissal is appropriate not only where the conduct of the government has been manifestly avowedly corrupt, but even where the conduct merely involves intentional intrusion into the attorney-client domain, resulting in prejudice to the defendant's case. For example, in Stein, the Second Circuit this is another case that they're referencing, United States versus Stein. They say, for example, in Stein, the Second Circuit affirmed the dismissal of an indictment against numerous defendants charged with a major tax evasion scheme because the government had interfered with their ability to retain counsel of their choice. The court affirmed Judge Kaplan's ruling that no other remedy would restore them to the position they would have enjoyed but for the government's unconstitutional conduct. Moreover, even as some defendants who were not deprived of their chosen counsel, the remedy was appropriate because the government had interfered in their relationships with counsel and impairment of their ability to mount a defense, including by impeding the scope of their pretrial investigation and preparation. Honey, do y'all hear this? Okay, somebody got off because of this before. See, this is what I've been telling you all from day one. This is what I've been telling you. Somebody else got off because of the same tactics being used. Now, Stein supports dismissal here, even though the government's misconduct has taken a different form in this case. The unconstitutional surveillance of Mr. Combs' notes about the preparation of his defense and privileged communications with his counsel have interfered with counsel's ability to provide effective assistance. There they go again. Okay, they keep saying that they're not able to provide him with adequate counsel. Okay. Now, with that all being said, just as the unconstitutional interference with counsel's fees did in Stein. Here, for example, although we do not yet know the full extent to which the prosecutors have used the privileged information, they cannot unlearn the preview of defense strategy they have obtained, nor can any other violative use of the privileged information be undone at this point. So they're saying it's too late. They already saw our strategy. Okay. They already know what we were planning. They've already seen the notes and have the information. They can't unsee that. Even if you say they can't use it, they're going to use it because they can't unsee what they've seen. Specifically, the government already admits that it has listened to Mr. Combs's calls, including with family members and his attorneys, reviewed his messages, including with dozens of individuals, including his attorneys. And as is clear from the government's reliance on Investigator One and its bail arguments, the government has not hesitated before affirmatively deployed Mr. Combs's privileged communications against him, saying that they already used it against him. That's why he didn't get bail. So we can expect that they're not going to keep using this stuff. That constitutes a violative use of the privileged information. And then they cite the case of Schwimmer II. To make matters worse, the communications at issue clearly gave the government a preview of defense strategy. Now, the problem in this case, however, is not that the government obtained incriminating statements or other specific evidence, but rather that it obtained information about Danielson's trial strategy. Now, that's where they're talking about this case, the United States versus Danielson. Now, they say the notes reference strategy to discredit particular allegations and corresponding witness testimony, to obtain a specific type of expert witness for trial, and to collect cross-examination material on particular witnesses. Thus, the prejudice to Mr. Combs's defense is clear, and dismissal is appropriate. That's what they're saying. Now, they're likely not going to get a dismissal, but what they might do, what they might get is if this goes to trial or when this goes to trial, that Diddy might, he might win an appeal. Okay? He might win on appeal. So it remains to be seen whether the government put Mr. Combs's privileged information before the grand jury or made any other use of the information. But notably, the government has never denied such use, nor has it disclaimed any intent to use the notes in the future. To the contrary, it stated that it would shy away from any suggestion that we put them in a vault and lock them up. Disqualification and other potential remedies. Now, depending in part on the nature and extent of the violation uncovered at the evidentiary hearing, the court should also consider whether other remedies are appropriate. For instance, if the court determines that dismissal is not warranted because a lesser remedy can cure the violation, this court should consider whether any members of the case team have been tainted in a way that warrants disqualification. Okay, it's basically saying some of these people may need to be put off the team. Okay, even if you feel like this is, we can just go ahead with this and have the hearing or whatever, some of these people may need to be taken off of the team, disqualified because of things that they've engaged in. This court has the power to disqualify individual government attorneys where circumstances warrant. Okay, they reference the United States versus Bolden. If any individual attorney engaged in misconduct or is irredeemably tainted by access to privileged materials or its fruits, the attorney should be disqualified. The court should also consider office-wide disqualification if the evidence adduced, which means brought forward at the hearing, warrants such disqualification. Additionally, this court should order the government to stop monitoring Mr. Combs's communications with his attorneys immediately. Federal law allows monitoring of attorney-client communications only in limited and extraordinary circumstances involving terrorism and the like. There is no legal basis for the government's monitoring of Mr. Combs's privileged communications in this case. Moreover, the government's conduct to date makes clear it cannot be trusted to respect the privilege or Mr. Combs's constitutional rights. Conclusion. For the foregoing reasons, the court should order discovery and hold a hearing, and should further order the necessary relief, including but not limited to suppression. Number one, suppression of the notes and any fruits of the illegal search. Two, directing that a special master conduct privilege review in lieu of the filter team going forward. Okay, so they don't want this filter team to have anything to do with it. They really want someone else in there because they clearly know at this point that they are not to be trusted. And from what she is saying, if all that she says is true, and I believe it is, then they're not to be trusted. Okay. So third, disqualification of any and all prosecutors tainted by access to the privileged materials. And fourth, ordering the government to stop monitoring Mr. Combs' communications with the defense team, and 5, depending on the evidence adduced at the hearing, dismissal of this indictment. Okay, I want y'all to pay attention, honey, because depending on what evidence they bring forward during the hearing, they're saying if it's something that's really problematic, yeah, we want an indictment. Okay, that's what we want. We want the indictment dismissed. A dismissal of the indictment. Honey, let me tell y'all something. This is all so crazy. Like I told you guys, what were the prosecutors thinking? What were they thinking? At the end of the day, this is all so crazy. So what do you guys think about all of this? This was a lot. Sheila Johnson said, wow, they cannot do that. Oh, yes, they can. Yes, they can, beloved. Maria says, change we can believe in. America has always been a racist, fascist state and one of the most dangerous places on earth. Children cannot even play safely in the park. That's why people are leaving. Okay, I'm not sure what that has to do with this topic, beloved. He acquired a new mansion with bars and he's being detained against his will. Not a mansion with bars, just like he did to others. No sympathy for the devil. Of course, we don't have any sympathy for him, honey. He's clearly nefarious. Nessa G said, by any means necessary, they have messed up. Yes, they have. Jay Gray said they are intentionally sabotaging this case. And that's exactly what I believe. Because the prosecution is not stupid, okay? The feds are smart. They know exactly what they're doing at all times. And at the end of the day, I've been telling you all this, that I feel like they're intentionally doing this to mess up this case. Pearlie says, time for these demons to go, Queen. Okay. Renee said he got a good lawyer. He sure does, because this lady knows what she's talking about. Okay, she knows what she's talking about. Joy says, I wonder if Diddy paid them off. Honey, let me tell you something. I don't know if Diddy paid them off, but what I told you all before was that I believe that, in fact, some of them might be on some of the footage. Okay, are the fans on the footage? Because why are they trying to murk up this case? Okay, why are they trying to mess up this case? It's all nefarious as far as I'm concerned. Okay, sounds like they might have something to do with it. Because it sounds like to me, just from the foolishness that continues to happen throughout this case, from the leaking of the Cassie video and to further things, little things about what's seen on the some of the freak off footage, okay, reported to the New York Post by an alleged agent and that's working on the case. At the end of the day, this stuff is all problematic. It just reeks of being all by design, as far as I'm concerned. It just seems like they're doing stuff on purpose at this point. Okay, I'm sorry. That's what it seems like to me. Now, I could be absolutely wrong, but then again, I could be absolutely right. So please pay attention. Okay, please pay attention. All right. So with that all being said, let's continue because now we got to talk about Drizzy. Okay, we got to talk about Drizzy because at the end of the day, a CNN anchor went in on Drake. He went in on Drake and likened him to a whole Karen, just like I did. I want y'all to pay attention, honey. I find it all so nefarious. Okay, CNN anchor likens Drake to a Karen while discussing UMG battle. And so Aubrey isn't safe anywhere, they say. Drake's stock is at an all-time low in terms of public opinion. The hip-hop world has all but rejected him after he announced plans to sue UMG and Spotify. The rapper alleges that the two companies worked in tandem to boost the streams of Kendrick Lamar's diss record, Not Like Us. Now, Drake supporters have tried to rationalize this legal action, but the bulk of hip-hop fans have effectively dubbed him a hypocrite and a whiner. It's absolutely true in my opinion. Now, it got worse on Monday, December the 2nd, because CNN aired coverage of the rapper's legal battle, and their anchors proceeded to dig into him as well. Okay, I don't know how Drake thought this was a good idea. I don't know what he was thinking. So CNN played footage from the Not Like Us music video. As the video package transitioned to the lead anchor, the network's take on the situation became clear. The anchor, like so many people online, feels that Drake is being overly sensitive about losing the Lamar battle, saying this may be the hip-hop equivalent of asking to speak with the manager. Okay, not the hip hop equivalent of asking to speak to the manager, Drake. You're going out bad. The notion of speaking with a manager is a joke that's tied to the Karen meme that has taken off in the last decade. The CNN anchor didn't say the name Karen, but in posting Drake as someone who asked for a manager, he indirectly is making the parallel. Okay, it's all so crazy. Oh, so crazy. Now, I'm not going to show that clip because they're playing the song Not Like Us, and I don't want any copyright issues. Now, this is not the first time a TV analyst has mocked Drake's legal situation. Last week, Kendrick Lamar's smash single TV Off played during the commercial break for TNT's Inside the NBA. When the show returned, guest panelist Jalen Rose commented on the song choice. He alluded to the fact that Drake plans to sue over a Kendrick Lamar song and quipped that TNT should try to avoid further legal action, saying, I don't know if y'all should be playing that Kendrick. This is what he says. Y'all gonna get a lawsuit up in here. The same day the CNN clip aired, Drake was made Donkey of the Day by Charlemagne the Devil. Okay, I call him Charlemagne the Devil, honey. Okay. And Charlemagne said, stop acting like you haven't been the beneficiary of record label technology. Okay, you're being a whole simply because you lost. Simply because Kendrick Lamar kicked your ace lyrically, spiritually, mentally, and emotionally. And anybody acting like this is anything more than anybody acting like this is anything more than Drake's feelings being hurt. You are you are a hoe too. And OV hole to be exact. Drake's case against UMG has been yet to formally launch, but it's clear he has been deemed guilty in the court of public opinion. Tough. Huh, they are going in on Drizzy. Okay, they are going in on Drizzy. BBL Drizzy is a whole Karen out here in these streets. Okay. Not calling anybody who's going along with him and acting like it's anything other than his feelings being hurt is an OV hoe. But here's the thing. Drake may have just a little glimmer of glee because they say Drake claims small victory over Kendrick Lamar as Spotify's most streamed rapper in 2024. Now, Drake has scored a minor win over Kendrick Lamar when it comes to year-end listener statistics. He's the victor when it comes to Spotify. Spotify just don't want Drake to sue. Please pay attention. On Wednesday, Spotify announced its most streamed artist globally for the year as part of its Spotify Wrapped campaign. Drizzy was the highest ranking rapper on the list. He was fourth overall behind Taylor Swift, The Weeknd, and Bad Bunny. The other rappers in the top 10 were Travis Scott, number 6, and Kanye West, number 8. Drake was also the service's most streamed rapper in the U.S. and second overall behind Swift. Kendrick was 7th on the list behind Swift, Drake, Zach, Bryan, Morgan Wallen, Kanye, and Future. When it comes to Apple Music, Kendrick had a notable upper hand as his Drake diss, Not Like Us, was the most played track of the year worldwide. Now, the streaming service made the announcement on Tuesday, November the 3rd, as it rolled out its top songs of 2024. Okay, global playlist. Shabuzi, a bar song, Tipsy was 4th, while Post Malone's duet with Morgan Wallen, I Need Some Help, was in the number 6 slot. Kendrick actually appeared in the top 10 for a second time via his beef starting feature on Future and Metro Boomin's Like That, which was number 8. Not Like Us actually received even more attention in recent days following Drake's bombshell legal filings against Universal Music Group. The chart-topping diss song is at the heart of the dispute, with Drizzy accusing UMG of artificially boosting the track's popularity through the use of streaming bots and payola, as they've done for him likely in the past. So Drake, please sit down somewhere. You're a whole hypocrite and a crybaby to boots. He has also, and a colonizer, lest we forget. He has also claimed that UMG, and see, that's why he thinks that he's supposed to be number one. Okay. That's why he thinks that he's supposed to be better than Kendrick. That's why he thinks that, how did I get here? How are they going for him and not me? Okay, that's what it is, because Drake's a whole colonizer, and he thinks that he's supposed to have privilege. Please pay attention. He has also claimed that UMG, the parent company of his label, Republic, and Kendrick's longtime home of Interscope, defamed him by knowingly releasing a song that accuses him of being a PDF file. Since he filed the petitions on November the 25th, sales for Not Like Us have increased by a staggering 440%, while streams of the song have jumped by 20%, according to Talk of the Charts. Not Like Us has also zoomed back up to the charts of both Apple Music and Spotify, enjoying a 16-place climb on the latter's global chart. Well, Drake, you brought this all on yourself, honey. That's what you did. You brought it all on himself. Okay, so he's sitting up there crying like a little old baby, whining, wham, wham. Somebody give Drake a pacifier, please. It's getting on my nerves. Okay, so that all been said, now he's catapulted Kendrick's song right back into the spotlight because the beef is like 6 months old. And here he goes rehashing it, okay? Trying to do dirt. And like I told you guys, basically trying to cause a distraction because he's upset and butthurt and been out of shape because Kendrick was chosen to perform at the Super Bowl halftime rather than his buddy, okay, Lil Wayne. You see how that worked out for him? See how that all worked out? Andrea says that Karen side of him is fiercely showing. Yes, it absolutely is. Okay, it absolutely is. All right. So anyway, with that all being said, I'm about to be out of here, you guys. Okay. So with that all being said, let me go to one more story I want to tell you all about real quick, and then we're going to be up out of here. But honey, this woman by the name of Karen, that's not really her name, but that's what I'm going to call her. She spat in a black teenager's face, and she got paid for it. That's her right there. Now I want you to pay attention because here's what Karen did. Just call a judge. White Wisconsin attorney spits in black teen's face. City ends up paying her $760,000 after cops flub arrest. And so a white Wisconsin woman who has served jail time for spitting in a black teenage Black Lives Matter protester's face has won a settlement for $760,000 after police broke into her home and arrested her without a warrant. Stephanie Rapkin was caught on video spitting in the face of a BLM protester on June 6th of 2020, for which she was later convicted of disorderly conduct. She pleaded guilty and served 60 days in jail, much to the disappointment of her 17-year-old victim, a black high school student who helped organize the rally and had hoped she'd receive harsher punishment. Now, but Rapkin's lawsuit centered around the actions of officers of two Milwaukee area police departments who came to arrest her the next day for an alleged assault. Now, according to her complaint, after the spitting incident, angry protesters went to Rapkin's house to confront her and verbally berate her. A young man in his 20s alleged that she came out of her home and pushed him. He called the police to make a complaint against Rapkin, who at the time was 63 years old. This is the chick that did the spitting in the kid's face, an officer said as he arrived on the scene. Now, this is all based on body cam footage. After reviewing the protester's cell phone video, officers from the Village of Shorewood Police Department decided to arrest her. Officers then knocked on her door and windows for about 30 minutes while discussing their plan to arrest her for disorderly conduct. They called for a female officer from the village of Whitefish to help with the arrest. They said if she comes out, arrest her. This is what one officer said. The other officers who then conspired to come up with a justification to break into her house, never considering obtaining a warrant, the complaint alleges. They found their false pretense. So after speaking with a neighbor who told them that Rapkin had taken a sleeping pill earlier that day because she was exhausted. So she's taken multiple doses of sleeping medication. This is what the police officer says, the lieutenant. I don't know. I don't know, the neighbor replied, prompting a police decision to do a welfare check on Rapkin. Now, in the video, officers are seen breaking through the front door and entering with guns and tasers drawn. They stood at the bottom of Rapkin's stairs and ordered her to come down and speak with them so they could check on her. Rapkin, who is an attorney, asked, "Gentlemen, do you have a warrant?" "We're here for a community caretaker, okay?" one officer replied. "I'm perfectly fine. I'm sleeping," she says, adding that she had not taken any sleeping medication and wanted them to leave so she could go back to sleep. Rapkin was then placed under arrest in her dining room where officers told her she was being charged with assaulting an individual outside, revealing their true motivation for going into Rapkin's home without a warrant. A scuffle then ensued, during which police claimed that Rabkin kneed an officer in the groin. She claimed they threw her up against a wall while screaming in her face. She was escorted from her home to applause from protesters outside and put into a police vehicle. The officers then proceeded to search her home for evidence that Rabkin had abused her medication, coming up empty-handed, according to the lawsuit. Felony assault charges against Rapkin for allegedly kicking the officer were later dropped. Rapkin lawyered up and her complaint filed in the U.S. District Court for the Eastern District of Wisconsin in May of 2023 charged police, including the Shorewood police chief, who approved the arrest, with violating her Fourth Amendment rights against unreasonable search and seizure. According to the complaint, a federal judge who granted a motion to suppress the evidence gathered from the search of her home agreed, calling the search outrageous police conduct and ruling that a reasonable officer would have come to the conclusion that either you need to get a warrant or wait till her attorney brings her down to the station house to talk, period. Rapkin's lawsuit sought compensatory and punitive damages against 8 individually named officers of the village of Whitefish and the village of Shorewood, alleging that the latter's police department has a policy of falsely invoking the community caretaker doctrine to break into private citizens' homes. The suit aimed to vindicate the violation of Rapkin's constitutional rights and to effect change through punitive damages by punishing the defendants for their total disregard of the Constitution, with the hope that the punishment is significant enough to prevent this from happening again. Now, both police departments denied all of the allegations of illegal or unconstitutional conduct in their answers to the lawsuit and also claimed qualified immunity from liability for their officers. Shorewood Village manager Rebecca Ewald said last week that the $760,000 judgment is not an admission of wrongdoing, but rather a decision to avoid the cost and risk of a trial. She noted that the city's insurance company, not its taxpayers, would be paying for the large sum that she was awarded in the judgment. The police officers had a really easy route to avoid trouble, which was just to call a judge. This is what Rapkin's attorney James Odell said. If they were truly concerned about Rapkin's welfare, he said, they should have left after confirming she was safe. You're not allowed to stick around and hope that you get the opportunity to do police activity when you were really supposed to be there to make sure everyone was safe, he said. Now, I want you all to pay attention. I want you all to pay attention to this, because at the end of the day, this is absolutely true. Her attorney is right. They were not supposed to go in there. Now, if they wanted to go in there under the ruse, under the guise that they were trying to see if she was okay from taking medication, as the neighbor alleged, then they should have left afterwards. And then they should have gone and gotten a search warrant. Okay, now I want you all to see how this devil got compensated for her nefarious behavior, because the police effed up. That's the same thing that I'm talking about in the case of Diddy. Illegal search and seizure is a problem, okay? That's the same grievance that the attorneys have filed in the case of Diddy, violating his Fourth Amendment right of illegal search protection against illegal search and seizure, as well as his Sixth Amendment right. Okay, so sometimes these things can absolutely happen, and of course it's not fair, and it's not how it doesn't seem fair, because you want the person who's the person who is the aggressor, or the person who is accused of the wrongdoing, you want them to be punished. But you see, when you F up and you don't go by policy and you don't follow the rule of law and you just do whatever you think you can do or whatever you want to do, these type of things happen. And that's what I'm talking about with the case of Diddy. So this is all problematic. Now this devil, this whole Karen, got compensated for nefarious behavior, pushing one person and spitting in the face of another. So with that all being said, they should have left after they confirmed she was safe. Now, Shorewood's police chief said that none of the officers involved in the incident were suspended or disciplined for their actions. So those are the breaks. That's what happens when you just do whatever you want and just say F the law. Okay, when you just say F the law, we're going to handle this our way. All right, we're going to do what we want. All right, because that's what it sounds like what the prosecution is doing in the case of Diddy, which isn't going to turn out good as far as I can see. Okay, unless they get it together. Now, when they have this evidentiary hearing, okay, hopefully the defense won't be able to prove that they're lying about what they have said. But, they probably are absolutely lying. They probably are absolutely lying. DJ Big Six said Diddy don't have the complexion for the protection. Well, here's the thing. At the end of the day, they could, if they prove that the prosecution has lied and the judge or special master, whoever is in charge over this proceeding, doesn't do anything about it, Diddy can still, file an appeal, like I said. And you don't need the complexion for protection for that, beloved. If it's blatant that the prosecution engaged in some unethical, illegal practices, if they engaged in something that is considered prosecutorial misconduct in any way, shape, or form, if they were doing things that were in violation of the rights of this person, they absolutely can get him off. Okay, that's what they can do. Because let's not forget, Diddy has money. This isn't like regular people. This is somebody who has power and prestige, okay? Somebody who's a whole celebrity. And we know that money talks, okay? Money talks, unfortunately, in the court of law. Okay, please pay attention. All right? Hope you all enjoy the rest of this day. And for those of you who follow the spiritual channel, we will again be on there. Today we'll be on there at 12:30. That's about 37 minutes from now. We'll be on there to continue reading the book that I'm reading for you guys. And this is for members. Okay. For the rest of you guys who are not members, I'll likely do something for you Friday or Saturday. Okay. So everyone enjoy the rest of this beautiful day. And whatever you do, beloveds, always remember to keep the Most High first in your lives. Peace.